I'll post a couple questions here because I think there's some good ones, and we'll answer it Texas specific, and then I'll comment on it on kind of California, and we can talk in general. So this one's going to start out very Texas specific. So this is from when we were talking about the standard possession order, or the expanded standard possession order that now is presumed. So if you go in and the judge has the ability to give you less than that standard possession order, what do you do in cases where you want that and then the judge orders something less?
Where you say when you want it, you mean like where if you want the other parent to have less
So you're the
time?
non-custodial. So you're the non-custodial parent, and you go in, and the judge orders you less time than even the standard possession order. What are your courses of action, or what are your next steps to kind of help protect your rights and increase the amount of time you have with your children?
Man, it's tough. You don't have a lot of next steps. I mean, if it's an associate judge, you can do what they call in Texas a de novo appeal and have the presiding judge hear it. But presiding judges don't want to go against their associate judges too often, so that's you have some success there. But in Texas, anything dealing with child support or possession or conservatorship, just about anything to do with the kid, it's revealed on an abusive discretion standard. And decisions regarding possession, child support, and conservatorship are rarely overturned. Uh, I mean, it's very, very rare. In fact, in Texas, the only time there's a heightened standard is if a judge says that you can have zero access to your kids. Well, the appellate court says, well, you can only do that if there's extreme circumstances, things like murder, hostage taken, and sexual exhibitionism. But short of that, a judge can do just about anything they want. So that just goes back to not pissing the judge off, you know. And I don't know. I guess to be specific, if I was representing a client and the judge gave them less than the standard possession order, I would, listen very carefully if the judge gave a reason, and I would look at the facts in the case to see if there's something we can correct.
Mm-hmm.
But short of that, not much you can do, man.
Yeah. So I mean, in a state like it's different from state to state. So you get your initial orders here in California, and I would tell dads, keep coming back, keep showing up, keep filing requests for modification, because a lot of times in California, when a dad is persistent and a dad keeps coming back and a dad keeps showing up and keeps asking for more and is there for the right reasons, usually the judge is going to be inclined to continue to give you more to a certain point. But there are other states. I know Oklahoma, your neighbor to the north, is one of them. You have one shot at temporary orders. They're going to set temporary orders, and the only other way really to get it changed is to go to trial. So for our viewers in different states, it's different depending on the state. Some states are going to be if you continue to show up, you're going to get more. Others, it's like, okay, well, we have to go to trial if we want to modify this temporary order, which California is on one extreme. A state like Oklahoma is on the other, where temporary orders are what they are.
Yeah, no, you can get in there and try to modify temporary orders, but the judges want to see a change, something that's changed. And so you always have that burden of a material and substantial change. So like within a suit, if you're in a divorce or suit affecting parent-child relationship, and right off the bat you get less than the standard possession order. Yeah, I mean, within that same suit, I would definitely, if you know kind of why the judge did that, go back to file to modify the temporary orders, and then at final trial too, I think that would be a case where maybe you do take it to a final trial, because generally you get at least the standard possession order, but like if you get less than the standard possession order, um, and then you have a final trial, yeah, you can file a modification and go back. But I'm sure like in California, I mean, it's a whole new suit. It's a ton of money, and It's a lot of effort. I guess it just depends on the reasons. If you can figure out why you got less than the standard possession order.
Yeah.